We'll hear argument first this morning in Case 1486, the Equal Employment Opportunity Commission versus Abercrombie Fitch stores. Mr. Gershengorn?
Mr. Chief Justice, and may it please the Court. The Tenth Circuit imposed two requirements on religious accommodation claims that eliminated liability for respondents' refusal to accommodate Ms. Eloff here. First, that the applicant herself verbally requests the accommodation, and second, that the employer know, rather than just correctly understand, the need for an accommodation. Neither requirement makes sense.
What is the difference between knowing and correctly understanding?
Your Honor, the testimony, it's a fair question. The Tenth Circuit perceived a difference. What the testimony was that Ms. Cook assumed that that Ms. Eloff needed to wear the headscarf because she was religious, that she figured that the headscarf signified that it was a religious headscarf, and that she figured it was a religious headscarf. What the Tenth Circuit said was that was insufficient. What was needed was actual knowledge.
Was that subjective? I'm sorry. Is that subjective, or is it even relevant? Meaning, the issue is whether they failed to hire her because of a religious practice. Whether the person thinks it is the issue. I mean, that's why they acted.
Yes.
Because I don't know why you just don't concede that that's a form of disparate treatment. Failure to accommodate is a form of disparate treatment. I don't accommodate you because of your religion. It's disparate treatment.
I just want to distinguish the different theories, because under a disparate treatment approach, there's as the lower courts have used it, you would have to show that it was because of the religious nature of the practice that you didn't accommodate. So, for example, again, that I allow hats for everyone, but not if you have a religious hat. That would be as the lower courts have called, a conventional disparate treatment claim.
Thank you, counsel. Mr. Dvoretsky?
Mr. Chief Justice, and may it please the Court, the premise of the EEOC's argument today, as I understand it, is that Abercrombie acted because of the religious basis for Ms. Eloff's headscarf. That is not correct as a factual matter, and the EEOC's theory in its brief does not depend on any such assumption. The EEOC's theory in its brief is that any time an employer suspects a possible conflict or correctly understands such a conflict, at that point it is on notice and must offer a religious accommodation.
Do you think that the employee has to say, I'm dressed the way I am for a religious reason?
Ms. Cook herself testified that she did not know that Ms. Eloff wore the headscarf for religious reasons. What we want to avoid is a rule that leads employers, in order to avoid liability, to start stereotyping about whether they think, guess, or suspect that somebody is doing something for religious.
This. All they have to do is say, this is what our look policy is. Do you have any problem with it? As Justice Alito pointed out a while back, don't have to probe anything about religion. I thought was his name Johnson? But he said, I would do the same thing with a man who came in with a yarmulke. So the man who came in with the yarmulke got the same treatment. Sorry, I was Miss Cook. I would want to hire you, but I can't. That was the answer that he gave. So there's no difference between the headscarf or the yarmulke or the Sikh turban in Mr. Johnson's view.
Thank you, counsel. The case is submitted.